Welcome back. We're joined on the sofa now by Dr. John Fox, who is the course leader of the Policing and Investigation degree. So inevitably, John, we're going to be talking about investigation. Good morning.
Good morning. Nice to be here. Nice to meet you all.
So we're going to be talking about the investigation of crime, and in particular what measures have been taken in recent years to prevent miscarriages of justice. But before we do that, what is a miscarriage of justice?
Oh, that's a good question, and many people, I think, automatically think, oh, when someone's sent to prison and they haven't done something wrong, and that's really one aspect. But justice is something that affects victims and offenders and defendants. So if a crime's not been investigated properly and someone's got away with a crime that they've committed, that's a miscarriage of justice in respect of the victim. The other thing I think that people get a bit hung up about is when a court case is overturned and it's then branded a miscarriage of justice. And actually that's not a good way of looking at things often, because it might just mean that the conviction was unsafe for technical reasons. Now, I'm perfectly happy with that. We have what's called a due process criminal justice system, which actually means that the bar to convict anybody is quite high. And it's hard to convict people in this country. But the fact that someone has had their conviction quashed or overturned by the appeal court doesn't necessarily mean they didn't commit the crime. It might mean that there was some flaw in the evidence gathering, they didn't have a fair trial. And I think a good example of that that's often quoted in essays, I'm marking a module at the moment for critical issues in public protection policing, which is a level 6 unit that some of the students might be doing. And some people are talking about the Sally Clark case, and she was a woman who was convicted of killing 2 of her children, couple of appeals, and then on the second appeal at the appeal court, she was acquitted. Now, the fact is, we don't know whether Sally Clark killed her children or not, and we never will do now because she's dead. But at the time, there was no doubt that a pathologist failed to disclose a test result relating to one of the babies, which could have indicated that that child had a disease. So whether or not she killed the children, I have no doubt that she did not have a fair trial, because that information should have been available to her and it should have been tested as to the plausibility of it. So that's what I think we need to think about with miscarriages of justice. It's not just where someone's languishing in prison for something they didn't do. It can be either when a police investigation has not found the guilty party and they've got away with it, or when there is some flaw in the system that meant that the person didn't have a fair trial and therefore their conviction was unsafe. How's that?
Yeah, brilliant. So in this country, we've had a long history of quite high-profile miscarriages of justice.
Yep.
What has happened in more recent years to try to address some of those problems? Perhaps identify as well, if you can, what some of those problems were.
Well, someone as young as me, I wouldn't be calling this recent, but in the 80s and the 70s, there were quite serious cases. I mean, the Confe case really is something that all students doing criminal justice ought to have a little bit of knowledge around. And the Confe case was about a chap who was a homeless guy in a derelict house. 2 or 3 young boys went in, I think they were around 14. They set fire to the house, and eventually they were arrested and they were interrogated for the murder of this homeless guy. Now, they were convicted, and it turned out later on, because luckily a lawyer took up this case and was very disturbed by the way the interviews were conducted. It came out that they had had little protection. The police had bullied the boys. They'd actually got their parents to... They bullied the parents to try and elicit a confession from these boys. So all of the kind of safeguards that we now take for granted were not in place in the Confe case. And that led to a lot of disquiet when these convictions were overturned. A judge called Lord Fisher was asked to do a review into it. He was very unhappy with the way the police were interviewing people. That led to another Royal Commission, which eventually led to a part of the Police and Criminal Evidence Act 1984, and Code C of that Act is all about how we treat people who are detained and how we question them. So all of that can be traced back to the Confay case, really. I'm not saying that was the only trigger, but that was one of the main triggers. So anyone who's writing about miscarriages, about interviewing currently, ought to really trace the journey back to that sort of case in the 70s where things were going wrong. Also in the 70s we had some high-profile IRA trials, and the Guildford Four is a good example where I think it's pretty fair to say now that the police did engage in some malpractice there. They tricked somebody into confessing by writing out a statement on a form, and then they took it into an interview room and said to one of the co-suspects, "Your mate's just confessed here, you know, you may as well tell us everything now." And they tricked. Now, you can't do that. Whatever people think about, well, it's fair game, it is not. And in our system here, we don't do that kind of thing, and therefore that again brought this whole idea of interviewing into disrepute, which again fed into this idea of having much more stringent safeguards around how we interview suspects. And the final case, which I think students need to look at around this area, is the Cardiff Three. And the interesting thing about that is that that case was investigated after Pace came in. And just a small bit of trivia here, okay? Although it's called the Police and Criminal Evidence Act 1984, it actually wasn't enacted for a further 2 years. Am I boring you here?
No, I know this one. It's good.
Yeah? You sure? Am I boring there?
Not at all.
Right. It actually came in 1986. So there was a small period of time, a couple of years, where although Pace appears to have been in, it wasn't. So anybody who's talking about a case in 1985 needs to remember that this is actually before Pace was enacted, because it took a while for all of the equipment to be set up. What did Pace bring? It brought a safeguard such as all interviews with the police now and suspects would be recorded in some way. And originally they were tape recorded, and much of the time now they're done on DVD. So the Cardiff Three case is a great example there, whereby although it, I think, happened in the 1988 or 9, when these people were interviewed, so Pace was well and truly in. The fact that Pace had come in gave an appeal court judge the opportunity to retrospectively go back and see how the interviews were conducted. So what happened here is that some people were wrongfully convicted, and I know that for sure, and I'll come to why in a moment. It got through the Crown Court trial, even though the interviews were very oppressive. The interviewers, the police were, you know, leering over the suspects, shouting at them, constantly haranguing them for many, many hours. The Crown Court judge accepted that those interviews were fair, and the people got convicted. Only on an appeal later did the appeal court judges have another listen to the tapes, and they thought, hang on a minute, we're not having this is awful. So they then overturned the convictions. Now, two things. We now know for sure that they didn't do it, because someone was later caught and DNA proved that they killed the victim, Lynette White. Okay, so that's why I'm safe sitting here saying that this was, without doubt, a miscarriage of justice. But the other thing that's important is it was only because of Pace coming in with this requirement to tape record the interviews that anyone ever knew what had gone on in that room. So I just think that, what was your question, by the way? Something about miscarriages. You know, that's where I think we've really raised our game in this country to ensure that not only will there not be as many miscarriages because of interview. And let me just say a thing about the police. You know, I'm not wanting to sound too harsh about the police. They don't want to wrongfully convict people. There's no value in that to the police, is there? You know, they don't want to just put someone in prison. I mean, I hope not, because that means that whoever did commit the crime is still out there doing whatever. But there are times when people do confess to things for all sorts of reasons when they haven't done it. And the police can themselves become victims of that. So for all sorts of reasons, this idea of recording, having transparency in the interview room is good. And it allows people to retrospectively go and check out, were things done in a fair way?
So most of the developments were around the Police and Criminal Evidence Act and around interviewing. Were there any other aspects? I
think a huge development in reducing miscarriages. Well, I kind of linked to it really. When I was talking about the Sally Clark case, a pathologist, a Home Office pathologist, got a test result back from one of the two boys that had died. And it indicated that the boy had some sort of it's a disease. It's called SA, Stachyorophophilis or something. And he found that because he thought the bug was in the lumbar, the cerebrospinal fluid of the child. Now, when he got the result back from the lab, he was convinced that the child did not actually have it. And I'm guessing now, but I think he thought that he may have contaminated the needle. So if you take the lumbar puncture fluid, and if you put the needle onto the mortuary table, which is full of bugs and disgusting stuff, you wouldn't want to eat a dinner on it, I'm sure. If he put the tip of the needle on the table, it had picked up the bug. He then squeezed the fluid into the little jar, sent it off to the lab. He's contaminated the sample, and the result came back from the lab indicating that this boy had a disease which the pathologist was sure the boy didn't have for some reason. So he buried it. And without a doubt, that was unfair, because the defence should have known about that. Indeed, the prosecution didn't know about it, so the CPS had no idea. And everybody would have had a chance to test that to see whether, in fact, the child did have the disease. But by the time it came out 5 years later, the body had been cremated and it was all too late. So this is an example of a failure to disclose important information to both sides. And I think this is the other key piece of legislation that I want to highlight, apart from PACE, which is probably the number one, but this legislation that came in 1996 called the Criminal Procedure and Investigation Act. And it gave a duty on the police initially to reveal to the Crown Prosecution Service any material that they had in their possession which they weren't planning to use as part of the trial. So you send stuff away to one expert in entomology, the study of insects, and say, you know, we want you to tell us when you think the body died that we found and got all these bugs from. This is disgusting, isn't it? They send a report back which indicates that the body had been in situ for 3 weeks. Okay, the police think, no, it can't have been there for 3 weeks because we've got 2 witnesses that walked that way and said that the body wasn't there. So that report now is a bit of a nuisance. It's inconvenient. So in the past, before CPIA came in, it was possible for the police just to sort of bin that and pretend it didn't exist. Now, that may affect any defence that comes up later on. If someone is eventually caught and arrested, maybe the fact that an expert had given some indication that the body had been in situ for a long time may affect their defence, because they may have an alibi for 5 weeks ago. Does that make sense? So now, anything like that the police have in their possession, or they're aware of its existence, they cannot just hide it and bury it. They have to reveal it to the CPS, and the CPS then will make a decision whether to disclose it to the defence.
And we've got a video on that actually that Marika Marika Henneberg talked about disclosure in England and Wales at the recent studies induction event, so we can make sure that our students can get that. John, I'm going to have to rush you because we've only got less than a minute left, but we have got a comment that's come in from Flippy, who says the breach of PACE in the Chris Halliwell case is interesting. It led to the location of a victim. However, as you recall, the actions surrounding the officer involved. Very, very briefly, how do you feel about that? He
breached PACE, and he had to make a decision. I mean, this is a very good case study. Again, one of my modules has got this as a question in the for the essays. That detective superintendent, Steve Fulcher, knew full well that he was breaching PACE, and he made the decision initially that the victim may be alive. So this is the victim that the taxi driver took from Swindon. Now, okay, you could argue that that was fair enough. She'd only been missing for a couple of days. So I think on that occasion it was justified that he breached PACE and did what was called an emergency interview in order to find the body. Where it all went wrong is that as he was at the scene in Savernake Forest, where Halliwell was showing him where that body was found, I can't remember, I mean, I don't know the full conversation, but it was something along the lines of the offender said, "Do you want another one?" Now at that point, once the officer knew that this was not a recent murder, he was out on a limb then. And he, instead of saying, "No, don't tell me now, we'll go back to the police station, we'll put you on tape and do it properly," he probably should have done that. He didn't. He let the guy ramble on, and the Halliwell said, "Oh, there was a body I buried 15 years ago in Gloucester." So they bimbled off to find that body. Now that was what the whole saga was about, really. And in the end, it got thrown out of court. But in the end, let's just finish the story, because although it was initially thrown out, Halliwell was convicted of murder number 1, but not number 2. So the family of number 2 were very annoyed. Steve Fulcher lost his job effectively because of all of this. And in the end, they did another investigation. They went to Halliwell's house, found a spade which had been sat in his garage for 15 years with the soil which identically matched the Gloucester site. So in the end, Halliwell was convicted of the second murder by proper means.
Yeah, but there was a breach of pace in the meantime. But an interesting case, no doubt, for our students. John,
a knowing breach of pace, not an accident, not corruption. He knew what he was doing, and he made a decision. It's more important actually to get justice here for the families than to worry about the law.
That's a whole interesting discussion as well,
It is,
isn't it?
and I wouldn't want to be in his position.
Yeah.
I have a lot of sympathy for him, but also the family who, at the time, did not get justice.
Yeah, absolutely. Thank you very much indeed, John. We could have talked about that for a lot longer. We will do it again another time.